I'm Jim Dodge. I'm a professor at Purdue Global Law School where I teach estate planning, real property, and contracts. What is estate planning? Estate planning is the process for arranging for the management and distribution of your assets after your death or if you become incapacitated. It involves expressing your wishes clearly and legally to ensure that your loved ones are cared for and that your assets are distributed according to your desires. While the first thing we often think of with estate planning is a will is only the beginning. Depending on your specific needs and wishes, you may want to avoid probate or you may need to reduce estate taxes, not to mention planning or how to handle things should you become incapacitated or unable to make financial decisions for yourself. And of course, there's more to estate planning than just asset transfers. It also involves setting up guardianships for minor children, naming beneficiaries for life insurance and retirement accounts, and making healthcare and end-of-life decisions. Estate planning is the way to address all of those concerns. Estate planning is important because it gives you control over what happens to your assets, your healthcare, and your loved ones if you're no longer able to make those decisions yourself. Without an estate plan, your property will be distributed according to the laws of intestacy in your state, which may or may not align with your wishes. This can lead to unnecessary delays, legal complications, and, sadly, family disputes. Estate planning provides peace of mind by ensuring that your instructions are clear, legally binding, and followed. A well-planned estate also prepares for the possibility of incapacity by providing for someone you trust to make financial and medical decisions on your behalf if you become unable to do so yourself. Additionally, a good estate plan should plan for guardianship of minor children when needed. It can also help minimize estate taxes, avoid probate, and provide privacy for your family. Estate planning is a must for those with complex assets, such as a business or significant investments, as well as those with specific healthcare or end-of-life wishes. It can also be used to provide for loved ones with special needs or those who may need ongoing financial support. If you don't have an estate plan, you are leaving the decisions about your assets, your healthcare, and your loved ones to the default provisions of the laws of your state. Here's what happens. First, your assets. Your assets will be distributed according to state law through intestacy. Without a will or trust, your estate will go through probate, a court-supervised process where your state's intestacy laws direct who inherits your assets. These laws follow a legal hierarchy, typically prioritizing a surviving spouse, children, parents, siblings, and then more distant relatives. However, if you have a blended family, an unmarried partner, or close friends you wish to inherit, the law will not account for your personal relationships. If you have no living relatives, your estate could even end up in the hands of the state. Without an estate plan, you have no control over how your assets are distributed. The probate process can be expensive and time-consuming. Probate is often a lengthy and costly process. It can take months or even years for your heirs to receive their inheritance. And because the probate process involves the court system, your financial affairs will become a matter of public record. With an estate plan, especially one that uses beneficiary designations and revocable living trusts effectively, you can avoid probate, ensuring that your assets are distributed quickly and privately. No control over healthcare or financial decisions if you become incapacitated. As I said before, estate planning isn't limited to asset distribution. It can also be used to address what happens if you become incapacitated due to illness or injury. If you don't have a durable power of attorney and a healthcare directive, your loved ones may need to go through the courts to gain the authority to manage your finances and to make decisions about your medical care. By appointing trusted individuals in advance, you ensure that your wishes are carried out by someone of your choosing. The court decides who raises your minor children. If you have minor children and you pass away without naming a guardian in your will, the court will decide who raises them. While judges do consider the best interests of the child, they may choose a guardian that you would not have selected. Higher taxes and unnecessary legal costs. Without an estate plan, your heirs may face unnecessary state taxes and legal fees. Effective estate planning can reduce or even eliminate these costs through ownership and transfer strategies. A well structured estate plan ensures that your assets are distributed according to your wishes, that your loved ones are protected, and that your affairs are handled efficiently. Planning your estate is one of the greatest gifts you can give to those you care about.